versus Lyle Menendez. He is in court with his attorneys, and the people are represented. This morning, counsel for both defendants and the prosecution were going over exhibits. And you're still working on that final list before you get to me?
We are not.
Okay. And at this point, we'll begin our discussion about jury instructions. Do both sides have the list prepared this morning by both sides that list both sets of instructions submitted by each side?
Yes.
Yes.
All right. Then what we can do is go through and get to the point of objections at this point from either side. And as I indicated, what I would propose to do at the outset is deal with instructions relating to credibility and the general role of the jury and the burden of proof, and set aside issues relating to the substantive offenses. We can hear a brief discussion of those, but final resolution of them will depend upon further discussions and completion of the evidence. So as I look at the list, the first instruction for which there is an objection is 1.25, submitted by the prosecution. Definition of a minor. What is the purpose of the instruction and what is the objection?
The purpose of the instructions, because of the testimony of the experts about their definition of what a child is, and the people have offered this to show that although the experts may think a child can be someone who's up to 30 years old, but the law recognizes a child to be someone under the age of 18 years.
Well, what the law recognizes and what a witness refers to in the witness's testimony are different things. And my question is, why is it material to the jury's fact-finding role that they know what the legal definition of a minor is? Just because somebody testified as far as how they view things.
Well, I also think that during the course of the defense case, that the defendants have been referred to repeatedly as the boys. And I think that people will be arguing that they are in fact legally recognized as adults and as men. So that's why we offered it.
All right. Is there still an objection by the defense?
There is, Your Honor. It's for the reasons already implied by the court. It's not a proper instruction. It's a matter of argument, perhaps, but it's this instruction isn't designed to be given in a homicide case.
All right. That'll be an instruction that will be rejected by the court. It's not relevant to the juror's role here. It doesn't have anything to do with the facts of the case or the charges.
Your Honor, I'm thinking that for time's sake, if the court's going to reject instructions which are germane to both defendants, that the other jury is objecting to, can we just, in other words, if you're going to rule against the people, and
then you can just withdraw it as to the other defendant,
okay.
But make a note of it so that we can correlate it with a list relating to the other defendant.
That's what I was intending to do.
Right. Then the next instruction is 2.03, submitted by the prosecution, objected to by the defense, and the defense has submitted a modification that would be offered if the instruction is to be given at all. And the people I take it object to the defendant's modification.
Yes.
All right, I have reviewed the modifications and I'm inclined to reject them based on the cases cited by the defense and other annotations to other similar instructions, specifically the case of People versus Crandall at 46 Cal 3rd 833, and People versus Breaux, BREAUX, at 1 Cal 4th 281, where instructions such as these were given without the modifications offered by the defense and were upheld by the Supreme Court. And the additional instructions are surplusage to what is already contained in them in the standard instruction. And I'll hear further from the defense if you wish to argue the matter.
Bernard Crandall is the case that we're relying on, as well as the others for this modification. And the objection is based on the fact that Crandall and the other cases cited to the court indicate that this instruction, this is page 871 of the court's opinion, quote, the instructions do not address the defendant's mental state at the time of the offense and do not direct or compel the drawing of impermissible inferences in regard thereto. And in this case, since identity is not an issue, the instruction as written is potentially misleading, and it does contain an unconstitutional presumption or inference as articulated in the objection in Crandall, that it allows the jury to infer consciousness of guilt as to the degree of crime simply from the making of false statements. And the Crandall opinion it rejects a sua sponte duty to modify the instruction, but it also points out that the instruction is not designed to apply to the issue of degree. It's really designed on the question of identity. And in fact, the court, at the same page, says, a defendant's guilt being the ultimate determination of the truth or falsity of the criminal charges, the jury might, according to defendant, view consciousness of guilt as equivalent to a confession, establishing all elements of the charged murder offenses, including premeditation and deliberation.
Actually, the facts of Crandall were such where the defendant admitted shooting and killing one of the two victims.
That's correct. Those were the facts of Crandall, and the objection being made here is the same one as being made there, but the court in the bottom line of this opinion does indicate that this instruction does not address defendant's mental state, and yet as written, it certainly can be argued and will be understood by the jury as reflecting on mental state, since that's the only issue they're being asked to decide is the degree of the homicide, not whether they committed the killings or not. And so a jury confronted with this instruction in this case, where the defendant concedes the issue of committing the acts but disputes the mental state, that can only be read by a reasonable juror as giving the court's endorsement to take false statements into account in determining the disputed issue of mental state.
All right, just hypothetically, throwing this out for discussion, if the issue was related to unreasonable self-defense and false statements were made, could not trier of fact interpret or consider those false statements in light of a proffered defense of unreasonable self-defense and infer that since the statements did not talk about or disclose any activity or reaction by fear or reasonable or unreasonable, that by making false statements that displayed a consciousness of guilt that does relate perhaps to the mental state and would be something that could be considered.
I don't think so, because Anderson, People versus Anderson, which is 70 Cal Second, the other case that talks about this and says, finally, the defendant in another case they're discussing there, as here, attempted to cover up the crime by lying to the brother and the mother of the victim. Although this type of evidence may possibly bear on defendant's state of mind after the killing, it is irrelevant to ascertaining defendant's state of mind immediately prior to or during the killing. Evasive conduct shows fear. It cannot support the double inference that defendant planned to hide his crime at the time he committed it, and that therefore defendant committed the crime with premeditation and deliberation. I think the court is clearly saying there that post-crime behavior, such as making false statements, although it may reflect the person's state of mind at the time the statements are made, cannot be used to support an inference of state of mind at the time of the crime.
Your Honor, I believe that we had this discussion, this exact discussion, when we talked about consciousness of guilt evidence when the people were trying to present it in the case in chief, and I believe the people presented to the court a more recent Supreme Court case than Anderson, in which the court held that consciousness of guilt does not go only to identity, but it also goes to the degree or the type of crime with which the defendant is charged.
I think you said the Nicholas case, if I'm not mistaken.
Yes, I have no recollection of the name of the case, but I'm quite sure that we found one.
So they did cite Nicholas, and Nicholas dealt with the flight instruction as well as false statements. And Nicholas says the instruction does not address the defendant's mental state at the time of the offense and does not direct or compel a drawing of impermissible inferences in regard thereto. So Nicholas really leaves it where Crandall discusses the issue, which is the court's assumption that this instruction was not designed to deal with mental state. And yet how's the jury supposed to know that unless the court instructs it on the issue? Because it certainly is not apparent. That may be the Supreme Court's interpretation of the instruction, but a reasonable layperson reading this instruction has no idea that this consciousness of guilt instruction is limited to the question of identity and has nothing to do with determining state of mind, especially in a case where state of mind is the entire issue being submitted to them.
Well, number one, one can respond to that by saying if the Supreme Court felt there was need for further clarification in a case where identity was not an issue, they certainly could have given us guidance in that regard. They didn't. And the language you have proffered here in these instructions is rather extensive and confusing and misleading. And I don't think this is what the Supreme Court contemplated in the language that you refer to. If they felt that way, they would have told us that this is what should be in the instruction. But in every case that you cited, they've upheld the instruction that you now want to supplement.
Well, in every case I cited deals with an issue where the defendant didn't request a supplemental clarifying instruction. The court's ruling in the context of whether the trial court had a sua sponte duty. And I think the issue is different where the defense asked for clarification based on the Supreme Court opinions in the area. Because the Supreme Court is saying in these opinions it doesn't relate to mental state, and that is the state of the law that they've articulated, and the defense is requesting that the jury be advised of what the true state of the law is.
All right, at this point, based on the argument presented, I'm satisfied that the instructions in the form provided by the Calgic Committee is the correct instruction to deal with this issue. I will, however, review the cases cited by the defense again and see if that would cause me to change my view of the matter. But at this point, the instructions will be given in their unmodified form.
Would the court consider an alternative then, which is based on this language in Crandall, which says a reasonable juror would understand consciousness of guilt to mean consciousness of some wrongdoing rather than consciousness of having committed the specific offense charged. And based on that language, we would request, in light of the court's denial of our modification, in the second sentence of the first sentence of the instruction posed by the people, where it says, "You may consider such statement as a circumstance tending to prove a consciousness of guilt." We would request that the words "consciousness of guilt" be changed to "consciousness of some wrongdoing."
My view is that the language of the instruction is the appropriate one, and I don't see any need to modify it to reflect the specific words in Crandall. This is an instruction that is past the test of time, and I don't think it needs any modification. All right, then we'll go to 2.04, which is basically the same discussion.
It is the same discussion, and without repeating that discussion, there's one additional objection which we would make in reference to 203, 204, 205, and 206, which is these are improper pinpoint instructions under People v. Wright. And People v. Wright says that the defendant is not entitled to a pinpoint instruction which draws the jury's attention to particular items of evidence and asks the jury to draw certain inference from that evidence. And all of these instructions are pinpointed toward the defendant and the defendant's conduct and the defendant's testimony. So an additional objection to the ones we've already articulated is that these are improper under People v. Wright.
All right, that objection is noted as well. It is true that there are certain standard instructions that are approved that relate to activities of the defendant and pinpoint that activity in a generic sense anyway, not specifically isolating exactly what the activity was, but in a generic fashion. But that's the law. That's the way the instructions have been drafted, and they have been approved many times. So that objection is noted, and the court will, as far as 2.04 is concerned, give it in its unmodified form, rejecting the defendant's version. And again, I will review these cases once more to satisfy myself that there is no, or whether there is a need for the additional verbiage that you've included here. 2.05, what does that relate to? What evidence in this trial?
That relates to Ms. Pizarczyk, where there's reference in the transcript and tape that I told Joel you wouldn't vote for him or something. I can't remember the exact words, but there was some reference to another person. So that's, does the court recall that?
Well, but he was directly soliciting someone to fabricate evidence, the defendant was.
Correct.
And isn't that covered by 2.04?
Yes.
But then the response that he makes when she indicates an unwillingness to do that is, I told Joel you'd say that, and the implication from that statement is that he in turn is acting on the advice of the lawyer at that point, is one possible interpretation of that statement.
Even so, it was his activity rather than that of another. Is this something that the defense wants in 2.05 rather than the prosecution? Seems like it's a duplication of 2.04. I envision 2.05 as an activity of some third party that is somehow sanctioned by the defendant.
Well, our position is, as we stated on our written instructions, is we are requesting this instruction in the modified form we've asked for it only if 2.04 is given, because I think it's a clarification of 2.04.
All right,
At least on the facts of this.
then you want 2.05 if 2.04 is given, but if 2.05 is given, I don't intend to add the additional language that you've added in the second paragraph, which I don't think is appropriate. I would give it in its unmodified form, which is as it appears in the CalJIC. So what was your position going to be on that if I don't give that second paragraph of 2.05?
Well, our third position would be you should give 2.05 in its CalJIC form if you're going to give 2.04.
Okay, and what is the people's position?
That's fine.
All right, then I'll give 2.05 in its unmodified form.
Now, when you're saying unmodified, are you referring to the changes that were made by the prosecution where we just took out the brackets and things like that?
No, I'm referring to the defense version, which will not be given. The unmodified version will be the standard CalJIC version
Okay.
dealing with the type of circumstance in the case as in the bracketed portions of the instruction. I don't have your instructions in front of me, so I'm not referring to those.
All right. That was my question.
And then 2.06. There is a defense objection to this and a request for similar modifications. Factually, this relates to what evidence in the case.
Box of letters, the backgammon box.
All right, I suppose it could relate to the guns, clothing, and other evidence that was destroyed or concealed.
Correct.
Could it not? All right, the court again would give this instruction without the defendant's additional verbiage, the second paragraph.
In addition to the objections we've already stated, we would object to the language about offering to compensate a witness. That is not factually supported here. And if that is meant to refer to the Pisarcik incident, it's already covered by 2.04.
That would be our theory, is that it's the bizarre incident where she was offered a sum of money in her account.
Yeah, and isn't that covered in 2.04?
Yes.
Is there a need for it to be duplicated in 2.06?
Not really. Does the court wish to delete the language then, as by an offer to compensate a witness?
Well, the only additional element is the actual offer to compensate, and that's not covered in 2.04. That is an additional element in addition to just soliciting somebody to act a certain way.
Seems to unfairly magnify one issue and break it down, compartmentalize it. I mean, certainly if the defense were in here arguing that because some witness testified to one incident and the incident contained 3 or 4 different components, and we'd be entitled to 3 different special instructions.
No, I agree.
It's
Your Honor,
really,
in light of the people's objection to all of the defense special instructions, why don't we delete the language that says an offer to compensate a witness from 2.06? And just, it will say, such as by concealing evidence.
All right.
Your Honor, we do have an objection factually to this instruction if it's being based on the box of letters incident. I understand the court's statement that this may apply to the concealing the guns and the clothing and things of that nature, but I don't think factually this instruction should be given if the court is basing it on the box of letters, given the fact that that box of letters has been revealed and turned over at this point.
Well, I have indicated that I think it's appropriate to give it in relationship to other evidence as to how it's argued. That's not really what we're dealing with at this point, but certainly the concealing of or destroying of evidence such as the shotguns and the clothing and the spent casings are all covered by 2.06. So it will be given. The next instruction for which there is an objection is 2.10.
Our objection to that instruction is based on the use note, which indicates this instruction will require revision if it is sought under Evidence Code Section 1251 to have statements of prior physical or mental condition considered as evidence of their own truth, which were made by a patient who was unavailable as a witness. That wouldn't apply, but the second part of it is this instruction should not be given in this form if testimony of the patient's statements is elicited to prove a prior consistent statement as provided in Evidence Code Section 1236. And we would be offering statements made by Lyle Menendez to the various experts as prior consistent statements for their truth, as well as to show the basis upon which the experts rely.
People wish to be heard on that.
Yes, our position is that the statements made to the experts in this case do not comport with Section 791B, which indicates the prior consistent statements have to have been made before the bias or motive for fabrication has arisen. It's going to certainly be the people's argument that in 1992, when these experts began to see the defendant, that was long after he had a motivation or a bias to fabricate, and therefore they are not prior consistent statements within the code section and do not meet the requirements.
And what is the defense response to
I
that?
think the problem with that is that people have alleged various theories of fabrication. And I think the theory she's pinpointed is one theory, but I also think it's been suggested to the jury directly through cross-examination and otherwise that they more recently have fabricated their testimony in these defenses. So it may not be responsive to the one fabrication theory that she has pinpointed for the court, but I think there are others that do need to be rebutted. And for that purpose, the statements to the experts would be admissible for the truth.
Do you have any particular statements in mind or just everything that was said?
Well, I think there are particular statements, and the problem thinking about this in formulating a special instruction, which would say these statements can be considered for their truth, but others cannot, is it seems to unfairly highlight certain statements.
Yeah, I wouldn't propose that we have such an instruction. I'm just curious as to what you were thinking of when you said that this testimony constitutes prior consistent statements. What specific statements did you have in mind?
Well, it would be certainly Lyle Menendez's statements about how the offense took place and his state of mind at the time of the offense.
Well, all of those statements were made to the experts after charges were filed and long after the arrest. So wasn't there clearly a motive at that point to, and the people's argument is that there was a motive to fabricate. How could you then use such evidence to buttress someone's testimony? Sure, you would object if the people offered a witness who testified and made a statement 10 minutes before they testified to somebody and then argue that that prior statement should be received for the truth of it as a prior consistent statement. It's just bootstrapping.
Well, I think our response to that is what I articulated before, which is it seems that the people have not pinpointed the point in time when the motive to fabricate has arisen. And it seems that throughout their attack, they've taken the position that they have in the past and continue to be fabricating their testimony.
Well, the fact that the people's position is that they might currently be fabricating, that's always a situation when somebody takes the witness stand and testifies and the opposition says that's a fabrication. And our position is that the fabrication just didn't start today, but it started years ago. And the proponent of the testimony has to then introduce something that pre-existed any such motive to fabricate to constitute a prior consistent statement.
Just reminded that there was testimony, cross-examination testimony along the lines of, well, what if a person had 3 years to study child abuse literature to concoct a defense? And under that theory of motive to fabricate, it would seem that statements made before that time period would be excluded or would be consistent statements.
Well, if the question contemplated a time frame that started 3 years ago and included the day of testimony, anything that occurred during that time frame would have occurred, any statement made would have occurred after the motive to fabricate already started. So I don't see how that really helps.
We're prepared to submit the issue at this point.
All right. The court is inclined to agree with the prosecution's theory that this instruction should be given in its format here. If you come up with some other argument, I'll certainly want to hear it as to why this instruction shouldn't be given in relationship to prior consistent statements. But as the evidence has been presented to me, it certainly would be a proper instruction.
Your Honor, there's one thing that needs to be changed, and in the body of the instruction, it says testimony of a medical expert, and I wasn't sure what we wanted to call the experts in this case. They're not, aside from Dr. Victory, I don't believe any of the other experts are medical experts, but I don't know what we wanted to term them unless we just wanted to leave it as an expert.
Well, certainly you want to get away, at least from this instruction at this point, and it might arise in some other discussions. Get away from Oziel and his testimony, and you're tying it into the witnesses who testified for the defense.
Correct.
I don't know how you want to characterize them. Do you have any suggestions?
How about defense expert? I think that the only experts they've called have been the psychological experts.
Well, I don't know if you want to label them in that fashion. Just they were all psychologists, were they not? or maybe, I guess they weren't.
No,
They
they
had
weren't.
different job titles. So how, Mr.
How about
Burt,
psychological experts?
you want to think about that and come back to it?
Yes, if we could.
Okay. All right, then the next instruction
220.
is 2.20.
Your Honor, I believe that the only difference between the one given by the defense and the one offered by the people is the last sentence of the defense instruction, which is past criminal conduct of a witness amounting to a misdemeanor. I believe that the defense is referring to Dr. Oziel in this particular portion, and it's the people's position that Dr. Oziel's conduct in having court today do some remodeling around his house is not conduct which amounts to misdemeanor, therefore this.
Well, let me ask the defense, what conduct was it that you were thinking of that was a misdemeanor? Because you have 2.23.1 as well.
This is a hard issue to discuss because we haven't had Ms. Smith's testimony, but I think by the end of Ms. Smith's testimony, we'll have at least forgery as a misdemeanor. And it I think will also be our position ultimately after she testifies that it's not, Wheeler is not limited just to misdemeanor conduct, that it would be any type of dishonest conduct that reflected on moral turpitude. But I'd ask the court to defer discussion on this issue until after Ms. Smith testifies and possibly Dr. Oziel if he's brought back, because I think by that time there will be some specifics. I agree up to this point. The only thing that could be identified possibly is the court day incident and the perhaps a submission of a letter that Oziel wrote to submit to a court.
All right, at this point, we'll defer that until the completion of the evidence.
But is the defense in agreement that that's the only difference?
Yes.
Okay. .24 is the next instruction then. Instruction is 2.62. Which is an instruction that directs the jury to the defendant's testimony specifically, and suggests drawing of certain inferences from failure to explain certain things. What is it that the people are specifically referring to in this? Well, I think generically his version of the crime itself and how the crime occurred, that is the entry into the den and the firing of the weapons in the den, as well as, and more specifically, their activities after the crime, which we believe will be shown to be physically or logistically impossible. Just by the tenor of the cross-examination of the defendant, there were many instances where he could not explain conduct on his part as to why he acted a certain way. And it's because of that the people have asked for 2.62.
Did you want to respond to that?
Well, I think that assertion is too vague to justify the giving of this instruction. The defendant was on the stand for days. He testified at length as to his explanation for every fact relating to this case, and I haven't heard anything specifically that has not been explained. And the use note to this instruction says that to prevent surprise and unfair advantage, it is recommended that the court consider requiring the prosecution to notify the court and defense counsel at close of cross-examination of defendant, or in any event before argument of intent to request the giving of this instruction and to state the claim evidentiary basis for the instruction, so that the defendant can have an opportunity to further testify. And I haven't heard anything which would require further testimony.
Yeah,
Your
I'm not.
disagreement with a story is not fair to explain.
Your Honor, I would ask that this be reserved until the end of the trial because there's now a significant piece of evidence which the people have at this December 11th date.
All right, at this stage, based on what's transpired, I'm not inclined to give the instruction. If the people have something that they're saving for argument relating to something they feel the defendant should have explained and didn't explain, something along those lines, that certainly can be covered in argument, but I don't think it's appropriate for the court to give instruction along those lines unless it was really highlighted during the examination of the defendant. So at this point, without further offer of proof, I'm not inclined to give 2.62.
May we hold off on that, Your Honor, until the end of the trial? Because
If something materializes, you can request reconsideration. At this point, it's going to be rejected. The next instruction is 2.70. And it's been modified by the defense. Which is really argumentative in the way it's phrased. I don't see any reason to go beyond the standard 2.70.
Your Honor, the last paragraph of the standard 2.70, which cautions about an oral confession should be viewed with caution, the use note indicates it should not be given if the statement is proved by a tape recording. So in light of the fact that many of the statements we have are on tape, that would be the 911 call, the December 11th tape, the talk with Sergeant Edmonds and also with Detective Zoller. Could this be, but then again, there's also oral statements that are not proved by tape. I think the last sentence needs to be modified.
Well, the people are suggesting that it be modified to delineate or distinguish oral statements from tape recorded statements.
Correct, and perhaps
Evidence of an oral confession or admission of a defendant that was not tape recorded should be viewed with caution. Is that what you're suggesting?
yes.
Defense, what should be heard on that?
We have no objection to that modification, Your Honor. Our concern with that last sentence is that as written and including the modification the court being proposed by the prosecution, it tells the jury to view with caution all evidence of an oral admission. So, for example, there are parts of Ozeal's statements which are unrecorded, which are helpful to the defense. Statements about the abusive character of the parents. And yet this instruction tells them to view that statement with caution as well. And that's why we had proposed that exculpatory statements made by the defendant should not be viewed with caution. That this instruction is really designed to apply to a situation when the prosecution is offering unrecorded statements, but certainly not to a situation where the defense is relying on helpful statements that are unrecorded.
Well, what you're really saying is that you don't think that last paragraph should be given at all.
That's fine with the people.
Well, no, I think they do, of course.
You want it.
If offered by the prosecution, they should be viewed with caution. That's the intent of the instruction.
Well, is it an admission then if it's offered by the problem is that the statements were offered by the prosecution and the defense wants to use them to its advantage, which obviously you're entitled to do. And it still remains an admission because it was offered by the prosecution.
Well, if the court is rejecting our proposed 2.70 as an alternative, we'd ask the court to add this sentence, which would say, any exculpatory out-of-court statement made by the defendant is not an admission and should not be viewed with caution.
Well, the problem I have is using the word exculpatory. What would that mean to a juror? You both can look at the same sentence or same piece of evidence and view it differently. One would say it's incriminating, and the other would say it's exculpatory. I don't know where you.
Well, that's true. It then would become a subject for argument as to what was exculpatory.
Well, I have problems with just the word exculpatory. I think it doesn't really address the issue. It doesn't. It's not clear enough.
Well, how about something like statements which are statements made by the defendant which are not in dispute? I mean, something like that, because both defendants admitted that some of what they told Dr. Ozil they actually told him. So the issue is what's in dispute. So perhaps we could factor something.
Okay, why don't you think about it if you can come up with something to deal with that concern. So there needs to be two modifications there, one dealing with tape recording and the other dealing with evidence that is being utilized by the defense that was not tape recorded. The people have also submitted 2.71. Obviously, we don't need both 2.70 and 2.71.
If the court's going to give 2.70, then 2.71 should be withdrawn.
All right. Then the next instruction is 2.71.5. And both sides have agreed to that one, so let's discuss that. Are there pre-offense statements that require 2.71.7?
I don't believe so.
I don't think so either.
Okay, and then we'll go to the next disputed instruction is 2.90. Of course, there is the standard instruction defining reasonable doubt that is based on Section 1096 of the Penal Code. And the defense has offered a modification, the second paragraph of this modified instruction. And perhaps you can enlighten me on the status of the cases right now that are before the Supreme Court.
Yeah, sure. Our objection is based on the case that has been decided by the Supreme Court, which is Cage, CAGE versus Louisiana, which is 498 U.S. 39, and also Sullivan versus Louisiana, which is 114 Supreme Court reporter. Don't have a page set on that, but Sullivan just follows Cage. And Cage dealt with a Louisiana instruction which defined reasonable doubt. In these words, it says, a reasonable doubt is not a mere possible doubt. It is an actual substantial doubt. It is a doubt that a reasonable man can seriously entertain. What is required is not an absolute or mechanical certainty, but a moral certainty. It must be such a doubt as would give rise to a grave uncertainty. And the U.S. Supreme Court struck down that instruction as unconstitutional under the Due Process Clause of the federal Constitution. And they did so in an opinion in which they say it is plain to us that the words substantial and grave, as they are commonly understood, suggest a higher degree of doubt than is required for acquittal under the reasonable doubt standard. When those statements are then considered with a reference to moral certainty rather than evidentiary certainty, it becomes clear that a reasonable juror could have interpreted the instruction to allow a finding of guilt based on a degree of proof below that required by the Due Process Clause. And based on Cage, there started to be raised in capital appeals in the California Supreme Court the issue of whether the California instruction was defective under Cage because of its use of moral certainty. And our Supreme Court addressed the issue in a case called People versus Jennings. And in Jennings, they rejected the argument that the instruction was defective under Cage, indicating that the wording in Cage was different since it referred to grave uncertainty, and since our instruction did not contain that language, it passed the test under Cage. And there are several other cases in addition to Jennings which have so held in the state Supreme Court. One of them was People versus Sandoval, and Sandoval filed a petition for cert this term with the U.S. Supreme Court, and the Supreme Court has granted cert. The case is still pending in front of the Supreme Court. The court also took another case from Nebraska on the same issue, the adequacy of the use of the term moral certainty. And the argument is basically that language does, because it does not refer to evidentiary certainty, it is violative of the reasonable doubt standard under the Due Process Clause, and it's also unconstitutionally vague. That's a petition for cert. So to preserve the issue, we are objecting and requesting the modification which we proposed. Probably will not be a decision until next term.
All right. The people wish to be heard.
No, Your Honor. I think that the standard instruction should be given.
All right. As I indicated to you earlier, that was my view as well. There's no way of anticipating what the United States Supreme Court would do. And certainly, even if they were to rule that our current instruction should be modified in some fashion, there's no reason to believe that the proposed modification that's set forth here would be the one that they would adopt. The standard wisdom has always been that any tinkering with the reasonable doubt standard and instruction from the one that appears in CalJIC 2.90 and Penal Code Section 1096 is certain to result in appellate disfavor, and the court is inclined to and would give the current instruction as it's embodied in 2.90, recognizing the defense position that it is attempting to preserve an issue. But at this point, the court has to rely upon the current case law, which sanctions the instruction as embodied in 2.90, and the court will give it in its unmodified version. The next instruction is 3.00, aiding and abetting, or principles defined, and then 3.01, aiding and abetting What is the people's objection to these? They were offered by the defense and the people object.
Yes, Your Honor. There's no theory of aiding and abetting in this case, I don't think. They're both principals who personally participated, and they both admitted they fired the guns. So I don't think, and they both admitted to committing a crime, so I don't think it's necessary to give this.
Well, the only possible theory would be as to which person fired which shot that killed which victim, I suppose, unless I'm missing something. Mr. Burt, what is it that you wanted to accomplish by this?
No, the court has identified what the theory is. There is ambiguity as to who did what.
Is there going to be argument by the defense that the people have failed in that burden of proof, that each defendant has not been proved beyond a reasonable doubt to have fired the fatal shot or a fatal shot that caused the death of each victim?
No.
If that's not going to be your position, why should we confuse the issue with the jury by giving these instructions? If you concede that they were principals, each defendant, or at least your client was a principal involved in the death of each victim.
I agree with that. I withdraw these.
All right, that would be 301 and 300. Then 331 has been submitted by both sides and will be given with the reservation that if the court acceded to the defense request for instructions on involuntary manslaughter, then this instruction will have to be modified in some fashion, but it talks about specific intent. But as it's written, without considering that aspect of it, it would be appropriate. .31.5 mental state. Both sides have submitted that one. I assume you're thinking of malice aforethought. Is that right? Is that the mental state that you're considering? Okay. 4.30 unconsciousness, or unconscious act, submitted by the defense. What is the evidence that supports this instruction?
The defense is relying on the testimony of Ann Burgess and certain testimony of the defendants indicating not being conscious of doing certain things, specifically their testimony with respect to the reload after the point in time when Lyle Menendez goes out to the car. I think several times during the course of his testimony, he indicated he just, in his words, freaked out. And I think Ann Burgess explained the biological basis for what was going on. So it's our position that this instruction is broad enough to cover at least that part of the testimony.
That he was unconscious when he fired the last shot into the mother?
Unconscious within the meaning of this rule, yes.
All right, the court doesn't find that the defense has offered any evidence to support this instruction, and therefore it would be rejected. And likewise, 4.31 then would be rejected as well. And 4.35 has been submitted by the defense, ignorance or mistake of fact. What was it that you had in
The
mind?
theory there is ignorance or mistake of fact as to the presence of danger. It's a self-defense issue, but I also think that this addresses it in a little bit different way. That
Right.
believed either reasonably or unreasonably in the presence of danger, and that under a certain view of the evidence would be a mistake of fact.
Well, this instruction would exonerate somebody if they had an unreasonable belief. You're arguing that if somebody had an unreasonable belief that they were in danger, they'd be entitled to an acquittal because of a mistake of fact.
Well, certainly it could, we would propose that it be modified to relate to the guilty of the crime of murder.
All right, the court finds that this is not an appropriate instruction in the context of this case, and any such instructions would be encompassed in the instructions dealing with self-defense or unreasonable self-defense if those instructions are given. Therefore, this is not an appropriate instruction, so the court will refuse it. And then the defense has submitted 4.43, which is defense of necessity, and you've submitted an affirmative defense requiring the defense to prove by preponderance of the evidence the issue of self-defense. Is that what you want?
Well, the issue of necessity. I think the burden is on this defense that we prove it by preponderance of the evidence, and the phraseology of this defense is different than self-defense. And yet I still think it does apply to the facts as testified to.
All right, the court doesn't find this an appropriate instruction, and again, this area, if it is subject to instruction, would be covered by the either self-defense or unreasonable self-defense or both, depending on how that's finally resolved. So the court doesn't find this is a case of defense of necessity, and therefore that instruction will not be given. And 4.71.5, I'm sorry, I've jumped 4.71.
4.71.5?
I think you have an objection to the people submitting 4.71,
Yeah.
and then they have an objection to your 4.71.5.
The objection I have to 4.71 really goes back to a comment the court made about the way in which the conspiracy charge was pled in this case, or the way in which the indictment was returned. And since the defendant cannot be convicted of an offense for which he was not indicted by the grand jury, 4.71 allows the prosecution to obtain an indictment for one conspiracy, and yet this language is broad enough to allow the jury here to determine that a separate conspiracy for which he's never been indicted could serve as a basis for the conviction. The evidence before the grand jury proved up, and they indicted him for a conspiracy on or about August 20th.
Yeah, so I'm looking at the indictment here. The indictment says the on or about August 20th. We did have discussions of this before the trial commenced as to why it was that this was the way it was alleged. Since there's an internal inconsistency in the pleading, because there is an allegation of an overt act that occurred on August the 18th. And overt acts are things that must occur after the commencement of the conspiracy, or they wouldn't be overt acts. All right, what is the people's response?
The people's response is that the pleading only needs to show on or about the date of the crime, and that the indictment so alleges that. And the conspiracy is alleged with such specificity, and the requirements of findings of the overt acts require those findings so that the jury cannot be confused that there's a different kind of conspiracy being charged. Well,
certainly the people have alleged language on or about August the 20th, which doesn't confine them to that precise date. And just because they introduce evidence that relates to events that precede the August 20th date, and there was some reference to the genesis of the shooting of the parents originating by one defendant and then the other watching a movie that preceded the August 20th date by a couple of weeks. It doesn't change the allegation or unfairly take advantage of the way the allegation is made in the complaint that it occurred on or about August the 20th. And certainly the defense is not taken by any surprise by the nature of the evidence offered.
Yeah, our position is it's not an issue of notice or surprise. It's an issue of the defendant's right to only be tried for the offense for which he was indicted. And I think our instruction, the 4.71.5 instruction, prevents the jury from varying the charge from what's been found by the grand jury.
All right, the court finds that the people's position is correct, that this was a crime that occurred on or about the date of August 20th, and the allegation is such where the conspiracy is alleged to have occurred on or about that date, and the way the overt acts are alleged, August 18th is certainly very close in time to August 20th, on or about that date. So the court is satisfied that that allegation is correctly pleaded, and that 4.71 is the appropriate instruction for the jury to have to deal with it. And the defendant is not being prosecuted for a crime different than that alleged in the indictment. So the court will give 4.71 and refuse 4.71.5.
Your Honor, just for the record, 4.71.5, the last sentence as offered by the defense is in conflict with 17.01 as offered by the people, which says that you have to agree to the particular overt act, the same one.
Well, we'll deal with that later on, but 4.71 is the appropriate instruction in this case. We have a series of instructions starting with 5.10. And going through 5.53, which deal with the subject of self-defense, imperfect or perfect self-defense. And we will defer final decisions on that until the evidence has been completed. If either side wishes to present to me your position now on the subject, I'll be glad to hear what it is as to your general position. What is the people's position?
The people's position as to perfect self-defense, as outlined in 5.10, is that the reasonable man standard has not been met in this case, therefore the perfect self-defense should not be given. And as well as the fact that imminence has not been, factually there's no imminence, which would kind of justify perfect self-defense. And as to imperfect self-defense, it's the people's position that the imminence requirement is lacking and therefore imperfect self-defense should not be given. I think the people are agreeing to the giving of the voluntary manslaughter instruction on a heat of passion theory, but not on a theory of imperfect self-defense.
You think that, or that is your position?
I'm just going to check the code really quickly, Your Honor. May I have a moment, please? Maybe Mr. Burt can state his position. No, we're not objecting to 8.40 as on a heat of passion theory, but so that's the distinction.
All right. What is the defense position?
Well, First of all, in that series, Your Honor, there are two distinct theories. One is 5.10, which is resisting an attempt to commit a forcible and atrocious crime. And that theory, I think, is supported by the testimony of both Eric and Lyle Menendez, and specifically the testimony concerning the point in time when Eric Menendez goes up to his room and is fearing at that point that the father is either going to kill him or come up and commit either an assaultive act, a homicidal act, or a sexual act at that point. And I think both brothers' testimony supports the view that one motivation at that point was preventing him, the father, from committing a forcible and atrocious crime within the meaning of these instructions. So I see that as a separate issue from the issue of self-defense. And as to the reasonable versus unreasonable self-defense, and whether obviously we think that the evidence in the case does justify the giving of both instructions. This is not a case like Eris, where there is a sleeping husband. This is more a situation where there are specific acts testified to by the brothers that in their minds justified fear, and the standard of the objective standard for self-defense does take into account the circumstances of the defendant. So it would, under our view, take into account the history of abuse that occurred up to the point in time when they had the final confrontation on August 20. And it's our view that the evidence as testified to them does justify both a perfect self-defense instruction and an imperfect self-defense instruction. And we will submit to the court some additional points and authorities on that specific theory.
All right.
One thing that I would like to answer, in 5.16, the defenses define sodomy and rape as forcible and atrocious crimes, which relates now to 5.10. It's the people's position, first of all, that men cannot be raped since they lack the necessary equipment to actually be raped. And it's the people's position in this particular case that that non-forcible sodomy is not a forcible and atrocious crime. And the description given by the defendant, Eric Menendez, of what he thought was going to occur did not amount to a forcible and atrocious crime. And I believe that one of the people's special instructions, which is not offered, it is offered in response to the potential of the court giving these instructions. I think that's special instruction number 3.
All right, the people's position is that the defense has not met the standard of the instructions or the prerequisites of the instruction dealing with, quote, a forcible and atrocious crime.
Correct.
And, all right.
And then secondly, that perfect self-defense should not be given because of the defendant's perception is not objectively reasonable under any definition of reasonableness, and therefore under Eris and other cases, that self-defense, purest perfect self-defense should not be given.
The way the defense has presented 5.16, it includes murder as a forcible and atrocious crime, and certainly it would be.
Yes.
But it begs the issue of the reasonable versus unreasonable standard that applies to murder and self-defense when that instruction is used. And it does seem to be bootstrapping Mr. Burt to include murder in that as a forcible and atrocious crime for which those instructions would apply.
Well, I think these are referring to the conduct of the victim. In other words, it's,
That's what I mean. That's what I mean. If you use that standard, you still have to have that reasonable man standard, don't you? For self-defense and or defense against a forcible and atrocious crime, not just a belief by the person who is acting, but a reasonable belief. And if it's an unreasonable belief, that's the people's position, as I understand it. Well, anyway, we're not resolving these things
Yeah.
now, but if you want to put in writing your positions on these matters, we'll,
I think that might be best.
right. Yeah, I'm not going to address these until all the evidence has been presented, since there apparently is more to come before we get to that. And each side is invited to submit in writing anything else that you have on the subject. I'm going to take a recess here and see if we can get some more information about the schedule for tomorrow. And then we'll resume once I get that information, if I do.
Maybe, so we're on 5-minute recess, please.
Yeah, 10 minutes.
There is also in the last 3 paragraphs an expansion of the concept that it's a subjective standard.
You've taken a complicated instruction and made it much more complex. I'll have to say that. You are to be congratulated.
Thank you.
Satisfied that 8.20 as set forth in the Calgic instruction adequately meditated murder. It's not required by law and is unduly confusing of the issue. Therefore, the court will give standard 8.20. All right, 8.31. Implied malice, second-degree murder. Eight 8.37 is the next one. And the people have indicated that they would propose an instruction on voluntary manslaughter as it relates to heat of passion.
Well, that's 8.40,
I understand that.
so I don't think 8.37 should be given.
All right. 8.37 delineates or distinguishes murder from manslaughter to the extent that it's an unlawful killing without malice aforethought. But so does 8.40, so that's not necessary. The only reason to give 8.37 is if the court was to give an instruction on involuntary manslaughter. So we can defer that until we get to that discussion. I'm not sure if the co-defendant was requesting an involuntary manslaughter I don't have that before me.
I don't believe so. I can check.
All right, my initial reading of their list didn't include,
Well, they asked for 8.27. They've asked for 8.37 and 8.4.
but they don't ask for involuntary, or do they? I guess they do, they do.
Yeah, they
I
do.
think they do, yeah, but they have different theories of, for involuntary, as I recall. All right, so we can hold off this discussion until we have both defendants here and deal with it together. So we don't have to do it twice. And 8.40, there is no objection. 8.42, there's an objection by the defense, but then a modification submitted.
I think they mean that they want theirs given and not ours.
That is what I mean by that.
Okay,
Fine, thank you.
all right. The defense has submitted a modified 8.42 dealing with sudden quarrel or heat of passion and provocation, reducing an intentional killing from murder to voluntary manslaughter. And which paragraphs have you added here so I can isolate on them?
The first two comport with these Calvic.
So you've added the third paragraph.
Third paragraph is an addition. The fourth paragraph is an amplification of the existing fourth paragraph in Calgic to take into account a history of provocation. And the fifth paragraph is also a amplification, as well as the sixth.
And what is the people's objection to the modifications?
Just the fact that it seems to be pinpointing prior history as within the instruction, and then I think that the 8.42 is sufficient to cover this particular theory. Also, the last paragraph of this modified instruction, I believe, dealing with reasonable doubt, is repeated later on in the instructions. There's several instructions that talk, if you have a reasonable doubt, you are to find manslaughter versus murder and things of that nature. So I think this is repetitive of other instructions that are being given.
My first suggestion is, without commenting on the specific language that you've added here, that 8.42 should be given separately. And if you have any modifications to the concept itself, you should submit them in a separate instruction so that we can deal with it separately.
I have in the special instructions.
Okay, so it's, if this was rejected as modified, you have something else to deal with this?
Yes.
Okay, all right, so that's how I would propose to do it. So I'm going to reject 8.42 with the understanding you have separate special instructions that deal with the subject.
So you're going to give 8.42 as in Caltech, correct?
Yes. And both sides submit. Have offered 8.43, and the defense has objected to it. It's a cooling period.
Objection to that instruction is that the instruction was really formulated to take into account the typical heat of passion situation, which deals with the emotion of anger. And that cooling period makes sense in the context of an emotion like anger, but does not diminishes over time. And that as a result, that this instruction is inappropriate.
So your position is that the emotion is fear?
Yes.
As in the emotional condition set forth in section 1016 of the evidence code, or
1016.
I think he needs a different one.
different emotion of fear?
No, it's the same emotion. It's not a mental or emotional condition, as the term is used in the evidence code.
Just
In any
testing.
In any event, I have thought of that, and I wanted to know for the court that these instructions were submitted after the court made the ruling that it did in that regard. So we're stuck with that ruling and have to make the best of it at this point.
Right. It seems to me that 8.43 is an instruction that should be given dealing with the impact or effect of the heat of passion on the individual, and whether or not there has been a cooling period, and whether the cooling period would have been sufficient in duration, or because of its nature to cause a reasonable ordinary person to no longer be acting upon such passion. So the court finds that 8.43 is an appropriate instruction and should be given. 8.44 is submitted by both sides. And then 8.45 is submitted by the defense, objected to by the prosecution. Involuntary manslaughter. And it's the defense position here that there has been evidence offered of an unlawful killing without intent to kill that would justify an involuntary manslaughter instruction.
At least as it relates to the the killing of the mother.
That there was no intent to kill when the shot was fired.
The reload shots.
Your Honor, the co-defendant has offered 8.45 as well.
All right, there were different theories, I believe, offered by the co-defendant, different acts, unlawful acts that were offered. So we'll discuss that in the context of both defendants. All right, we'll hold off on that so we don't have to go over it twice. And 8.50, let's see, the next objection is, well, what is the people's position on 8.74? It's been modified by the defense and you don't state a position. Okay, the only, I guess you're holding off on the involuntary. Okay.
Correct.
All right, 8.75.
I think that should only be given, Your Honor, if the jury needs direction.
The court does not intend to give 8.75 unless it's requested by the nature of the deliberations. I think it creates more confusion than resolves by giving it. And if it's responsive to inquiry by the jury, then I think it would be appropriate, but at this stage, the court will refuse it. .80 has been modified by the defense, and people object to the modification, or you submitted your own. What was the modification on this one?
I think that, they added in the aider and abettor. That's some language, but I think that's the third paragraph, the second sentence, second line.
Well, the difficulty in dealing with these when they're submitted in this fashion is that it's hard to pick out what it is that was modified.
Your Honor, it's paragraph 3, which is not, I have the 1990 revision of 8.80, which is what they have, and paragraph 3 is not in the CalJEC.
.80, paragraph 3.
Yes.
It is in Cal.
Yeah, it's,
Oh, it is?
yeah, it's just that they've modified it, reduced, eliminated some of the brackets. That's always a confusing paragraph. And
Oh,
it's hard
okay.
to follow
I'm
the meaning of
confused
it because of
because
the brackets.
the people's submission is not the 1990 version.
Okay.
And
It is, I just took out that whole middle bracket, that's what happened. Because the last portion certainly doesn't apply of that third paragraph. Yeah, I took out that paragraph because I found it to be inapplicable if that's the case. Perhaps we need to discuss it, because I may have been in error.
I think it is applicable. That's the only modification that I made, was to take out the brackets.
Okay, your modification is on that third paragraph.
Correct.
That's always a confusing paragraph. Let's just hold off on that one, and I think it's probably going to relate to the co-defendant as well. 8.80, third paragraph. .81.15 is the next instruction for which there was a modification.
Yes, I think I found this modification. It's kind of like playing find Delvo, but it's the last paragraph. There's a 1, 2, and 3. 1 is concealment by ambush, and I don't think that's what the statute of CalJEC requires.
It certainly is not what the CalJEC requires. The modification here, Your Honor, was made to conform the line and weight special to our position that was advanced to the court on our demur, which is that as presently interpreted, the instruction and the cases under it is so broad to take into account any homicide. So we have proposed to the court that the concealment of purpose language be deleted from the instruction, and also that the jury be instructed that a substantial period of watchful waiting is an element of the special circumstance. And as the CalJEC is written, instead of telling the jury that in an affirmative way that a substantial period of watchful waiting is a necessary element, CalJEC deals with that issue by defining it negatively and saying the line and weight need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. So you have the anomaly that first-degree murder with a non-special circumstance requires premeditation and deliberation, but the special circumstance of lying in wait can be something that's equivalent to premeditation or deliberation. And you have the further anomaly that the special circumstance is defined in terms of what the people need not prove, as opposed to affirmatively setting forth what the elements are. And the cases clearly say that a substantial period of watchful waiting is an element of this special circumstance, and yet nowhere in the instruction is that element spelled out. And then, as I say, the second modification is to delete the concealment of purpose language.
We've changed it from concealment of purpose to concealment by ambush.
Correct.
And then in the third paragraph, well, it starts with the term while lying in wait, which starts at about line 15 on this page. They removed some of the calendar, which talks about concealment by ambush, and they took out the following, or by some other secret design to take the other person by surprise. So they modified the words.
All right. did
And
you want to
our
respond to that?
objections are based on the Eighth Amendment and the due process clause of the federal constitutions, that language is vague and overly broad and encompasses virtually any killing. And so we've attempted to narrow it to make it something above and beyond what a normal first-degree murder would be.
All right, the court finds that it is obligated to give the instruction as provided by the California Supreme Court decisions that deal with this subject, including People versus Morales, which was the basis of the 8.81.15. And that is an instruction that is appropriate and covers the definition of murder while lying in wait. And the court will give that instruction in its unmodified form. So the defense instruction will be refused. The next instruction is 17.01.
Your Honor, the difference between the one submitted by the defense and one by the prosecution is the use note indicates that where there's conspiracy, you need to add the words overt in front of the word act. And so that's what I did. I changed that.
I mean, it says all jurors must agree that he committed the same act or acts. You put in overt act.
Yeah, that's, yes, Your Honor, that's what the use note indicates should be done if there's a conspiracy.
We have no objection to that.
Okay.
I think the defense needs to compare them. I also wrote up.
Was modified by the defense. And the defense has enumerated lesser offenses of involuntary manslaughter. Now that one is
That's a
an interesting concept for sure. So then that instruction deals with conspiracy to commit voluntary manslaughter, and there was some discussion about that. And I'll read the case that was cited. Other than the voluntary manslaughter portion of that instruction, do the people have any objections to it? Other than the fact that it's already covered in other instructions, the jury will have already been instructed on, as to counts 1 and 2, murder, first and second degree, and voluntary manslaughter. So there's really no need for that again. The only need perhaps would be on the third count of conspiracy. to have the lessers of second degree or voluntary conspiracy to commit those if the court gives those.
So there's no need to give the second degree is a lesser, or voluntary is a lesser, or involuntary, only the conspiracy is that.
Normally, you wouldn't be giving it twice. It's already covered in the homicide instructions that there are 2 degrees of murder, and there's also manslaughter, and jury must be convinced beyond a reasonable doubt as to which unanimously to come up with a verdict. So I don't think you need it twice.
Well,
Want to be heard on that?
I think that the first 2 paragraphs of the instruction are a predicate for the third paragraph, which gives the jury some guidance on how they go about determining the order in which they decide graders or lessers, and I think that is required.
All right, that is something that we can consider. That is not included in the homicide instructions. The paragraph that was added within the last few years dealing with how the jury approaches its task, dealing with their various options. All right, this relates also to the voluntary manslaughter and the co-defendant. So if this instruction is given, and also with count 3. So if the instruction is given, we'll hold off and discuss it with the co-defendant.
The only other thing I wish to add is the concept of lesser included offenses is sufficiently complex that it would not hurt to repeat it, even though the court has, to a certain extent, covered it in the instructions on homicide.
All right, we'll hold off because we have to discuss that with the co-defendant as well. And the defense has submitted 17.11. That is covered by the homicide instructions.
8.71 is the
Yeah.
smallest big diagram from Ron.
There's no need to give that twice. So that will be refused. And the next instruction for which there is, or to which there is an objection, are just the specials. Both sides have objections to the specials.
Your Honor,
Sorry, can we return to 1711?
Yeah.
The prosecution indicated that was covered by what?
8.71.
Thank you.
Do you agree with that?
Yes.
Okay. Then, yes, you were saying something before we got to specials.
17.49 is something we need to wait on because it's just how many verdict forms are there. So we just need to-
Right, that's something that you can just give me a blank form and we'll take care of it. All right, so we have all of the specials to deal with, so it's already 5 o'clock, so you want to do that tomorrow?
Yes, please.
We deferred, since the specials all relate to the self-defense instructions, I wonder if we could defer that until when we discuss the self-defense issues with the co-defendant present, since I think we'd have to repeat a lot of that discussion. I also think our time would be better spent in preparation of the testimony and our final argument, so that we wouldn't have to come back to it.
Are all of these instructions, well, let me back up and ask you whether or not you've discussed these particular instructions with the co-defendant and if there's some conformity with your offers and theirs, or if they're entirely different.
It's my understanding that they're going to be requesting some of ours be given as well. And they do relate to heat of passion and self-defense. So I think they're better discussed when all parties are present.
Okay, do people want to respond to that?
That we should wait?
Yeah.
Yes, I think we should.
I'm sorry?
Yes, I think we should wait.
All right, it does seem that they do relate to the same issue that we'll discuss with both defendants. All right, so
What do you want us to do tomorrow?
well, is there some matter that has to be resolved in any fashion whatsoever outside the presence of the jury with this defendant alone that we can deal with?
No, I don't think so. The only thing I would like is,
Have you finished that list of exhibits that was worked on by both sides, both defendants?
There are just, I think there are about 4 other areas that the people have to make a decision about whether they're going to object or not.
there's some areas that are delineated, they're very clear that we just aren't sure yet. The reason I'm asking is I would like to come in tomorrow and check the exhibit list against the exhibits. We got up to 100 today, but there's quite a few left, and that needs to be done before we finalize this.
Fine.
But I don't think anyone wants to be here unless Ms. Lansing wants to join me.
Oh, I see.
The exhibits will be here, I'll be here, the clerk will be here,
Okay.
and the sooner you can give me the final list of exhibits in dispute, then the sooner I can look at them. And this is a combined list prepared by both defendants, is that right?
Yes.
Okay.
Why don't we give you the list now, and it's very clear the things that have question marks mean we're not ready yet. But everything else, I think, the court could look at.
All right.
I'll call you.